The Honorable Supreme Court of India on 25th of November 2024 dismissed a bunch of petitions challenging the inclusion of words secular and socialist in the preamble to our Indian Constitution as per the 42nd Amendment Act of our Constitution in 1976.
We, the people of India, having solemnly resolved to constitute India to a sovereign, socialist, secular, democratic republic. I'm reading from the first page of the Indian Constitution, and this is what the first line of the preamble says: sovereign, socialist, secular, and democratic.
The bench, comprising of Chief Justice of India Shri Sanjeev Khanna and Shri Justice Sanjay Kumar, observed that there is no legitimate cause or justification for challenging this. And in its verdict of Dr. Balram Singh and others versus Union of India, the court has emphasized the widespread acceptance of these terms and the clear understanding of these terms by the people of our country. Also, it has ended the 5-decade-long debate of inclusion of the words socialist and secular in the preamble to our Indian Constitution. The Honorable Supreme Court of India also said that secularism mandates that the government does not favor any religion, but it does not prevent the elimination of religious attitudes and practices impeding the development and right to equality in our country. This statement is very important. Now, what was the original preamble? How it has evolved over the years? What is the debate around inclusion of this secular and socialist word in the conclusion? And what is the Honorable Supreme Court of India's judgment? All these questions we'll be trying to answer in this particular session. Hello, my name is Preamble Singh and you are watching Perspective. So the story so far is that a division bench of the Supreme Court led by Chief Justice of India Shri Sanjeev Khanna has dismissed the pleas challenging the inclusion of the words socialist and secular in the preamble of our Constitution. Now, through the Constitution 42nd Amendment Act of 1976, which is also known as Mini Constitution, the Parliament during emergency, it enacted a sweeping series of amendments to the Constitution, one of which labelled India as a sovereign, socialist, secular, democratic republic. Although the Supreme Court of India curbed many of the amendments made under the 42nd Amendment, but it refused to interfere with the phrasing of the preamble at that point of time. And as the history of the preamble goes, the preamble to our Constitution, it clarifies the guiding principle and the purpose behind framing the Constitution of India. So it is an integral part and scheme of the Constitution, and it is non-justiciable, which means that a violation of a principle under preamble cannot be a reason for you to go to courts in India. However, the judges definitely can use preamble as an additional factor in their reasonings and in their judgments. And when the Constitution of India first came into force, that is on January 26, 1950, the preamble stated that we, the people of India, having solemnly resolved to constitute India to a sovereign democratic republic and to secure to all of its citizens justice, socio-economic, political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and fraternity assuring the dignity of the individual and unity and integrity of the nation. Now, if you see the starting line, where sovereign democratic republic is there, two words you will not find a mention to. That is socialist and secular, because these two words were added to the preamble later on and they were not a part of the original preamble to the Constitution. The phrasing of the preamble can be traced back to the first week of the Constituent Assembly debates, especially the date of December 13th, 1946. On this day, the foremost Prime Minister of our country, Prime Minister Pandit Jawaharlal Nehru, he introduced objective resolution in the Constituent Assembly. And it unanimously adopted a 8-point pledge that provided the guiding principles for drafting of the whole Constitution. Also, amongst all these things, it also declared the intent of the Constituent Assembly to proclaim India into an independent sovereign republic and also guarantee equality before law and safeguards for minorities in our country. Now, one thing is very clear, that in the original preamble, the words socialist and secular were not there. But during these debates, early attempts were made to introduce the concept of socialism into the preamble. For example, in October of 1949, Constituent Assembly member Hazrat Mohani, he moved an amendment for the preamble, and he said that the preamble should begin with, "We the people of India, having solemnly resolved to constitute India into a union of Indian Socialist Republics to be called as UISR, that is Union of India Socialist Republic, on the lines of USSR." he said that this line shall be included as the starting point of our preamble. Of course, this amendment was eventually rejected and the preamble as we know now today was adopted. Of course, after that there have been certain amendments made. Now these attempts, they were not confined just with preamble, because earlier in November 1948 also, the Constituent Assembly member, a very prominent one, Professor K.T. Shah, he also moved an amendment to Article 1, Section 1 of our Constitution. He suggested that it should include India, that is Bharat, shall be Union of States. He said that what is now called India, that is Bharat, shall be Union of States. It should say India, that is Bharat, shall be Secular, Federalist, Socialist Union of States. So he wanted to include these terms of socialist and secular in that particular Article 1, Section 1 of our Constitution only. And also this motion or this amendment was eventually rejected as well. But there was one assembly member known as H.V. Kamath who noted that the words of secular and socialist could find a place, if at all, only in the preamble of our Constitution. Now let us know about the views of the founding father of our Constitution, that is Dr. Ambedkar, also known as father to our Constitution. He had two objections to the proposal laid down by Shah at that particular point of time. And this formed the bedrock of his vision of India as well. And his vision, it placed the democracy and the will of people at the forefront, rather than focusing on fixed ideological positions. Now his central argument was rooted towards commitment to democracy. He firmly believed that constitution is a mechanism to regulate the functioning of a state. He categorically pointed out that constitution should not be considered as a document which imposes a particular social or economic ideology to the future generations of the country. That is not why the constitution is being framed. And while he was responding to K.T. Shah's proposal, he said that what should be the policy of the state, how society should be organized in social and economic terms or economic side are the matters which must be decided by the people themselves according to time and circumstances. We should not impose that on them by including these things in the constitution, and which is why he said that we should not include the term socialist. Now coming to secularism. Dr. Ambedkar was a very strong advocate of keeping religion out of politics, and not only him. The first Prime Minister of our country, Pandit Jawaharlal Nehru, was also believing the same. And also, they both argued that this term secular need not be explicitly mentioned in the preamble of our Constitution. And Dr. Ambedkar said that in our Constitution, we have already made it clear that India would be a state that did not recognize any religion. His ideas were implemented in different articles which we can see in the Constitution. It can be in relation to religious freedoms and the non-alignment of state to a particular religion, which can be seen in Article 19 to our Constitution and also Article 16. Now, this article prohibits discrimination against any person on the basis of religion. On the other hand, Pandit Nehru believed that secularism in India is built differently from its Western counterparts. So Indian secularism is different than Western secularism. He said Western secularism primarily addresses the historical conflict between the church and the state in Europe. But contrary to this, he says that the religious landscape of India was intertwined with politics, and that secularism in India has to be understood in a different way and in a more functional and flexible concept way. So with this discussion, one thing is clear, that our Constituent Assembly, they avoided the word socialist explicitly because they felt that declaring the economic ideal of a country in its constitution's preamble would not be appropriate at all. And people should decide what suits to them according to time, circumstances and age. And likewise, if we talk about Indian secularism, since it is different than the Western counterpart, it is different than West, the government is not agnostic to religion. In the Europe, in the West, religion and state is totally separate. But India, if you see, India will give Hajj subsidies also. India will help or aid in Kailash Mansarovar Yatra also. Will do a lot of activities in Darbar Sahib as well, in Jain Mandirs also. So in a lot of religious places, you will see Indian government playing a proactive role. So Indian government is not totally divided from the religious activities. However, India will not discriminate against any religion. That is the philosophy or the core philosophy of Indian secularism. So in India, state has the power to regulate the economic, functional, political and secular aspects related to religious practices. It can also provide for social welfare and reform in religious practices as well. So India's secularism is totally opposite and completely different than the Western counterparts. Now further, various provisions of the Constitution, they include the right to practice any religion, the non-discrimination on the basis of religion and equality of religion in our society already enshrined in our Constitution. And hence in Constituent Assembly, The amendment to include secular was also not accepted and was eventually rejected. Also, in one of the landmark judgments in Berubari case, the Honorable Supreme Court of India opined that preamble is not a part of the constitution, which is why it is not a source of any substantive power. However, subsequently in Keshwananda Bharati case in 1973, the Honorable Supreme Court of India reversed its earlier judgment, said that preamble is a part of the constitution and that constitution should be read and interpreted in the light of the vision enshrined in the preamble. And it also held that preamble would be subjected to the same amendment power of the parliament as any other provisions of the constitution. So, preamble can be amended by the Indian Parliament. And finally, during emergency, 42nd Amendment Act of 1976 was passed, and it inserted the terms secular and socialist to the preamble of our constitution. And this constitutional amendment is also known as mini constitution because of numbers and expanse of changes which were introduced in it. Now, since the chronology is very clear, in 1976 the terms secular and socialist were added. Now, the whole discussion or the whole controversy is around this, because many people or many experts, they say that these words should not have been included because they were not there in the original constitution. But many experts say that since these words reflects the basic philosophy of the constitution, adding them to the preamble does no harm to our country, does no harm to our constitution also. So these are the two sides which are fighting, and which is why there have been a case put in the Honorable Supreme Court of India challenging the word secular and socialist which were added through the 42nd Amendment Act. And now what we need to discuss is the Supreme Court of India's judgment under Dr. Vajiram Singh and others versus Union of India case. So in relation to context of 42nd Amendment Act, the petitioners argued that the amendment was introduced during the emergency imposed by Indira Gandhi ji's government, so they were questioning its legitimacy. The Supreme Court pointed out that this issue was deliberated during the Constitution's 44th Amendment Bill of 1978. And they retained the terms after extensive parliamentary discussion. So that is what Supreme Court said. Now, in relation to Parliament's power to amend the preamble, the bench argued that under Article 368, the power to amend the constitution, it extends to amending the preamble as well. And hence the argument against retrospective amendments, they were rejected. And the bench also stated that accepting the retrospective amendment would undermine all the constitutional amendments despite Parliament's unquestioned authority to amend the constitution, because constitution is a living document. Also, the Supreme Court highlighted that inclusion of these two words, they highlight India's evolving democracy and a social framework in a way. And the court also questioned the petitions filed in 2020. 44 years after the amendment, noting that the widespread acceptance of these terms in India has already been there. Also, the court interpreted the two terms, that is secularism, which means that the state shall remain neutral. Neither they endorse any religion, nor they should be opposing any religion. This principle is enshrined in Article 14, 15 and 16 of our Constitution. They say that the term socialism, it does not constrain the economic policies, but reflects the state's commitment to building a welfare state, towards formation of a welfare state in the country. And eventually the court highlighted that inclusion of these terms secular and socialist in the constitution has not done any harm to our country, and also it has not impeded any legislation or governance, and it provided they align to the constitutional rights and the basic structure doctrine of our constitution. And eventually the Supreme Court of India said that these two terms, they highlight the democratic principles and inclusive governance in our country. So finally, the Supreme Court of India's verdict, it reaffirms the validity of 42nd Amendment to our Constitution in relation to adding these two terms, socialist and secular, to the preamble of our Constitution. And it also highlights the power of the Parliament to adapt to India's ever-evolving societal and democratic needs. Now, I would like to end this session by a very famous quote of Mahatma Gandhi ji. He says that I do not want my house to be walled in from all the sides and my windows to be stuffed. I want the culture of all lands to be blown about my house as freely as possible. Now, I hope you gain new perspective from this session. What are your views surrounding inclusion of these two terms, and should they be as a part of preamble or not? Do let me know your views in the comment section. I'll be very happy to read them. All the very best and have a beautiful day. Thank you.